Okay, I'd like to start the Transportation, Energy, and Utility Committee meeting with the City Council at 5:01. And I'd entertain a motion on the agenda.
So I will move the agenda with the note that the 5 minutes on the North Winooski Avenue update number 6 is insufficient because of a complaint by a business owner that I need to bring to the here and then to talk about. So as long as we know that that is the case, I don't know how long you'll want, but I would like a real conversation about it.
I'm open to that. I added times to the agenda just to give us a framework to work within tonight.
Beautiful. In that case, I would move the agenda as drafted with that understanding.
I'll second. All those in favor?
Me.
Me too. Next on the agenda is approval of the minutes from our 8:15 meeting.
So I'm going to move their approval, but I have not actually read them. So they don't have to be approved anyway. So if I come and find some mistake somewhere down the line, then I'll let y'all know.
Okay, I'll second that. All those in favor? Aye. Next up is public forum. We don't appear to have anybody in the room, which is very atypical of a two meeting recently, but I'm sure we have some folks online. So,
Jonathan Scott, you should be able to unmute.
hi, Jonathan.
Hi, everyone. Thank you. Can you hear me okay?
We can.
Great. Thank you for the opportunity to speak briefly. My name is Jonathan Stott. I am a resident of Burlington, Vermont. I'm a user of the airport. I've had the opportunity to connect with you all before, and I want to say thank you for the work you do to make the airport a really good airport, and I use it a lot for work, so thank you for that. I am going to go on comment and recommend that you all consider banning F-35s from the airport, as well as private aircraft. And I think today you're going to see a presentation, I'm sure you've all already looked at it, that's going to provide a very easy opportunity to say there's nothing that we can do. And I would encourage you all to think about this particular moment in time and your role within it. All of you have an opportunity to do something that 20 years later you can look back and say, when there was a climate emergency, I had the opportunity to step up and do something within my space, and I did it. So I would encourage you guys, when you go through the process of learning about the rules and regulations concerning essentially a city's response, like the city's inability to restrict aircraft and aircraft types from the airport, I would remind you to consider that all movements are created through breaking rules. And that's what has to happen for us to change the system so that we can work ourselves out of the planetary crisis. And we have all been living through probably the hardest summer on record here in Vermont. And we're seeing it from air quality. We're seeing it in our water quality. And we know that aviation accounts for a significant driver of emissions. And yes, the decision to ban F-35s, it won't have a massive measurable impact on global emissions, but it's a statement. And it's a statement that Burlington as a city is leading and taking steps to make changes to save our planet. And so when you have the opportunity to consider what it would look like, I would ask yourself to think, what would it look like for us to make a recommendation that, yes, it breaks the rules, and to see what the FAA does. And I would say start with the F-35s. Again, I'm a user of the airport. I'm not suggesting that we eliminate the airport entirely, but I think there's an opportunity here. And I would hate for us to miss it as a city and for you to miss it as leaders. And thank you for your time today. I appreciate it.
Thank you, Jonathan. Who's next, Matt?
No one else has their hand raised, but if anyone would like to speak during public comment, you can use the raise hand. Ashley Adams.
Go ahead, Ashley.
Hi there. Can you hear me?
We can.
Okay, great. As any decision maker will attest, there are any number of justifications, including expert opinions, such as the one that you're being presented with today on the airport, that will ostensibly prove to you why you must maintain the status quo. or that will help you justify, in this case, for example, not doing what you must do to salvage a habitable planet, or to explain why it is acceptable not to stand up for residents in neighborhoods surrounding the airport who are suffering daily from the onslaught of F-35 noise. And today, I'd like to just take a few minutes to share the voices of some of my tenants whose lives are affected by the F-35s. I have 3 statements that I'd like to share with you tonight because they can't be here. One tenant shared this: the F-35s are extremely loud. I think it's hard for people who don't live right here to understand. I have the opportunity to work from home or have needed to due to childcare issues or illness, but can't because the jets are simply way too loud and disruptive. During COVID, when I was forced to work from home, there were times when clients in crisis would hang up on me because they couldn't hear me or me them for such an extended period of time that they didn't know what was going on. My partner is in the early years with his own commercial cleaning business, and he works at night. He suffers from insomnia, and when he gets woken up, it can be very difficult to fall back asleep. When the jets take off in the morning, it's only about halfway through his sleep time. They are so loud that they're impossible to sleep through. There are so many of the jets. Lack of adequate sleep is very harmful, especially to him because he has a brain injury and requires a healthy sleep routine to function more than the average person. The jets make it very difficult. There's no such thing as sleeping in when the jets take off. We all want to sleep in sometimes. I've had headaches, the flu, etc., and the jets only make things worse. I've been so upset when I had sick kiddos that were up half the night and finally getting some sleep when the jets take off. If you are outside when they take off, it's very uncomfortable and simply too much. It's so loud, it's difficult to handle. We have to go inside the second we hear them. When my kids were younger, they would get really scared and run inside covering their ears. A second tenant shared this: I'm lucky I don't work at home, but I've also experienced when the girls are sick and I have to be at home and don't have a babysitter. The F-35s are loud, painful, piercing sounds, and it's not just one jet, at least 6 or 7 fly by, one after the other. And honestly, I've been so scared that the house would crash in on us when the jets fly by. There are cracks on the house that could be from those jets. Luckily, they've never flown by at night, but if they did, it would be terrifying. Imagine being woken up by that sound. This is a truly beautiful place to have a home, a family. The nature around us makes it all better to call home. I hope they get rebased. And a third tenant shared this: the F-35 noise doesn't bother me so much because I believe it protects our freedom. Our country is challenged with its values, which is freedom. When I look around the world, what's going on, I always pray to God to continue to protect America. Only here we have freedom and free speech. So many places you can't speak about this on TV and go home and sleep peacefully. You may not see your family again. At work, we really enjoy seeing them take off. We run outside to see them take off. Only when we have an important call, you can't hear anything, but it lasts for only 10 minutes. My kids are terrified by the noise. They run out inside the house or hold me by fear, but they are still little. I don't want anybody to take away my freedom. So USA, USA. These voices represent just a few of the people who suffer daily, including those children, because no public official in this state has the decency to, number one, say that people like my tenants matter and that their suffering is unacceptable and it's wrong. And number two, seek ways to right that wrong. And number three, persist until the harm is stopped. Thank you.
Thank you, Ashley.
There's one other person, but they don't have their hand raised, so I think that's.
Are there any others who would like to speak in public forum? If so, please raise your hand so we can recognize you. Hand raised. Okay. Well, with that, we'll close public forum at 5:10, and the next item on our agenda is a presentation from the airport on the city's authority to regulate airport. We have excellent here. Yeah, absolutely.
Perfect, thank you. Thank you, Councilors, for having us, for inviting us. I'll just do a quick round of introductions. This is Dave McCormick. Dave is our Deputy Director of Aviation Operations, of course. You know Kyle Klaus here from the City Attorney's Office, And online, we have Nick Clobbers with our outside counsel for the airport and for the city. You know, we heard a lot about this from previous public meetings, public forums at the airport commission meeting and the TUC meeting. So I think our presentation is tailored somewhat to those comments from the past. We did present this very similar presentation to our airport commission with some various questions. And again, Nick Clavers was able to adjust it based on the comments received then, but I'm going to hand it right over to Nick to go through the presentation and of course, answer any questions.
Did you say there was an extra slide that you're gonna have?
Nick just sent Maddie an extra slide presentation. I don't know if you're presenting or if he's presenting.
It's I was going to run it from my computer, Nick.
Great.
And it's not an extra slide, but I've made some asterisks where I made edits to the version that you all probably saw beforehand. I know there was a question that came in about an hour ago, and we wanted to make sure that we address that. So I'll go ahead and share my screen. Hopefully everyone will be able to see that. Is that visible to everybody?
It is.
Okay, great. Well, first, I just want to say thanks to Nick and to this group, the committee, for having me here. And I know that there have been a lot of questions raised around the city's ability to restrict or regulate aeronautical activities at the airport. And as Nick said, we gave a very similar presentation to the Airports Commission about 3 weeks ago. So we're just going to review this. And I want to preface this by saying this is intentionally something of a high level presentation. And I'm going to, hit the very top line bullet points of the relevant pieces of legal authority here. I'm happy to answer questions at the end of the presentation, but there's a large body of law behind a lot of these concepts. And really my objective here is in, approximately 10 minutes or so to just hit those top line pieces so that we really understand what it is that we're working within. Let's see, come on, there we go. So just a quick background on myself and our firm, Kaplan, Kirsch & Rockwell. We are a national law firm with a focus on representation of airports. We don't represent aircraft owners, airlines, pilots, or aeronautical service providers. We pride ourselves on being real advocates for airports, and we don't take positions that are adverse to airports. So we have a lot of experience in this arena, and we've counseled many clients on potential aeronautical access restrictions. So what are the questions that have been raised around BTV and different aircraft operating at BTV? The questions that have been discussed with me and I think with Nick and for some of you as well, what is the city's legal authority to prohibit or restrict aircraft operations at the airport? What is their authority to require that only aircraft meeting a certain fuel efficiency standard or a certain noise standard may operate at the airport? What's the authority to limit military operations or to prohibit the sale or use of leaded aviation fuel at the airport? The addition that I made here is just the asterisk on noise standard, and I want to highlight that right now to say that most of these bullet points are sort of taken under the same general concepts. Noise standards are subject to a slightly different standard that I'll talk about on each particular slide here. The top line answer is that the city has essentially no authority to adopt or enforce these types of restrictions. And again, the asterisk there is that noise restrictions are subject to a slightly different standard, a different legal standard as to when they may or may not be permissible. But the practical standpoint or practical reality is that those noise-based restrictions are still very difficult to adopt or enforce and are subject to a very high threshold for enforceability. So the top line consequences here or the attempts to adopt or enforce restrictions like the ones that I just put in the previous slide likely would result in FAA enforcement actions, informal or formal complaints from airport users or industry groups. And ultimately, if those problems are not corrected in the eyes of the FAA, it could result in the city losing eligibility for federal grant funds. That's generally the final step in the process. So what are the legal sources of the city's the legal restrictions on the city's ability to enact these restrictions? The first that we'll talk about is the city's grant assurances. The second is the very broad concept of federal preemption in the airport and aviation context. And then we'll move to just a quick discussion of two specific federal statutes, the Airline Deregulation Act and the Airport Noise and Capacity Act. And each one of those particular statutes has a specific preemptive effect on these types of regulations. Excuse me. Here is not cooperating. There we are. So to start off grant assurances, you all may be familiar with the concept of the federal grant assurances. These are obligations that are established by federal statute as a condition of receiving FAA grant funds. So each time the city accepts a federal grant from the FAA for development projects at the airport, repaving a runway, reconstructing an apron, lighting, signage, all sorts of different things that the city regularly accepts funds from the FAA, they sign an agreement that requires, as relevant here, the city to make the airport, quote, available as an airport for public use on reasonable terms and without unjust discrimination to all types, kinds, and classes of aeronautical activities. And I bolded that reasonable terms and without unjust discrimination because, as we'll see on the next slide, that really is the key part of the analysis here. The city also commits itself to avoid granting a, quote, exclusive right to use the airport, and also to permit, quote, government aircraft to utilize all facilities at the airport. And there's a very broad definition of government aircraft that would include military aircraft as well. So restrictions on aeronautical activities may be reasonable and not unjustly discriminatory if two factors are met. One, if they are justified for aeronautical safety reasons, and two, if they are approved by the FAA. They have to meet both of those factors. As a general rule, prohibitions on certain types of aircraft are rarely acceptable, and it's only if the aircraft cannot be safely accommodated. And when we talk about being safely accommodated and the concept of aeronautical safety, what we're really talking about and what the FAA is really talking about is airspace considerations. There are many instances where things like skydiving or hang gliding or ultralight aircraft, for whatever reason, are not safe to operate within the airspace of a certain airport. What does not fall within that aeronautical safety prong are things like fuel efficiency and pollution. Those have other safety implications, but it's not part of the analysis that the FAA makes when they look at restrictions under the grant assurances. Restrictions on aeronautical activities for reasons other than aeronautical safety, that is, if the airport is making a distinction between type A aircraft and type B aircraft, and that doesn't have anything to do with whether the runway can accommodate that type of aircraft, for example, those would most likely violate the grant assurances. The requirement that the airport be open for all types, kinds, classes of aeronautical activities. Otherwise, that restriction is considered most likely unreasonable and or unjustly discriminatory. So moving to federal preemption generally, the FAA has exclusive jurisdiction over many, many aspects of aviation. That includes aircraft in flight, airspace, and aircraft fuel efficiency. And local attempts to directly or indirectly regulate those types of things may infringe on FAA's jurisdiction and therefore would be invalid. There's a large body of case law out there that discusses airports' attempts to regulate, for example, certain routes of aircraft taking off from an airport and going to a different airport. That is preempted under the large federal scheme that encourages national regulation of the airspace and not local regulation. The asterisk that I've added there is with respect to noise. Airport proprietors do have the ability to regulate certain aircraft operations on the basis of noise. The issue becomes that those regulations must be, we can go right back to this slide, reasonable and not unjustly discriminatory and not arbitrary is another term of art used by some courts to describe that ability. The issue with noise-based restrictions is that the FAA is the one that must pass judgment on whether those are enforceable. Very, very similar to the analysis under the grant assurance that I cited in the previous slide. This is not to say that noise-based restrictions are impossible. They are just very difficult, and the FAA requires a pretty substantial showing to believe or be convinced that those are viable protections of the airport's local community. With respect to all of the other issues and sort of distinctions that I drew, aircraft fuel efficiency, the sale of leaded aviation gasoline, those types of things, the FAA has taken the position, at least with respect to the sale of leaded aviation gasoline, that any local attempts to ban that sale or to regulate the sale of aviation gasoline does infringe on the FAA's federal jurisdiction. There's a recent case out of Santa Clara County, California, where the airport proprietor, in that case, the county, which owns and operates 2 airports, took steps to prevent all of its fixed base operators from selling aviation gas. They essentially passed an ordinance that said we will no longer enter into any leases with any fixed base operator that sells leaded aviation gasoline. And the FAA sent a letter of investigation to the county, claiming that action violated the grant assurances and several principles of federal preemption. And that case is in abeyance, but the county is also the target of a complaint from the Aircraft Owners and Pilots Association alleging essentially the same thing. And that portion of the case is still ongoing. So it's just to illustrate that those are the types of restrictions that the FAA views as very much infringing on their jurisdiction, and the FAA is pretty aggressive about defending its jurisdiction in those instances. So the 2 specific federal statutes that I just want to raise in this context are the Airline Deregulation Act and the Airport Noise and Capacity Act. So to start with the Airline Deregulation Act, it expressly preempts any local law or regulation that relates to the, quote, prices, routes, or services of an air carrier, with some very limited exceptions that really would not apply here. And the point that I want to raise here is that airlines are well known in the industry to be very litigious when it comes to any local regulation that is arguably preempted by the ADA, meaning anything that arguably touches their prices, routes, or services. As you might expect, airports and airlines have different definitions of things that may relate to prices, routes, or services. Airports generally think that what they adopt is very narrow, and airlines think that everything airports do affects their prices, routes, and services. It's very difficult to say, whether a given restriction, for example, on fuel efficiency of aircraft using the airport, would in fact be preempted under the Airline Deregulation Act. But the takeaway is that if an airline, even a single airline or some airline industry groups believe that it did, the chances of them filing suit to stop that type of restriction are relatively high. Airlines have fought this in courts across the country. They've made many attempts to get various ADA issues in front of the Supreme Court. This is not a sort of fake sword that they wield. They try to invoke this at every opportunity. The second federal statute is the Airport Noise and Capacity Act. And this is a procedural statute that has requirements for adoption of any airport access restriction. And this really goes back to the noise restriction piece that I mentioned before. The FAA and Congress have permitted proprietors to enact noise restrictions under very limited circumstances, but there's an empirical showing that's required of airport proprietors and FAA approval, and a substantive threshold that needs to be met under the regulations to permit that restriction to become effective. Since the adoption of ANCA in 1990, no airport has successfully adopted restrictions on any modern aircraft. So it's very few airports have attempted it, and those that have attempted it have failed for one reason or another. So what are the likely consequences if the city were to adopt a restriction without following some of the ANCA rules in the case of noise, or to adopt a restriction on one of those other bases that I mentioned earlier? The most likely consequence is an FAA enforcement action or investigation. The FAA, as I mentioned in that Santa Clara case, takes a pretty proactive approach to asserting its jurisdiction and patrolling potential violations of the grant assurances. Generally, what that looks like is an FAA first letter of investigation that starts either an informal or formal proceeding that proceeds similar to a court case, but not quite exactly the same. The ability also exists for formal or informal complaints from airport users, airlines, or industry groups. The applicable regulations here under 14 Code of Federal Regulations Part 13 and Part 16 are pretty broad in allowing essentially anyone that feels they may be adversely affected by some type of violation on the part of the airport sponsor to file a complaint with the FAA, and that's adjudicated much the same way that an FAA-initiated complaint would be. They are long and painful processes. It is not uncommon for them to take anywhere from 2 to 4 years to resolve completely, unless the airport sponsor changes its ways and comes into compliance in the eyes of the FAA. Adverse findings in one of those proceedings could result in an FAA or court injunction against enforcement of any of those restrictions. The FAA often will withhold federal grant funds, even in the absence of adverse findings. They won't officially declare an airport sponsor to be ineligible, but they have discretion to withhold new grant funds during the pendency of an investigation. Ultimately, if the sponsor is found to be in violation and refuses or declines to change its behavior, the FAA can declare that sponsor ineligible for future grant funds. And in extreme cases, the FAA has the ability to issue civil penalties for certain violations. So that's a very high-level overview. And I understand that I have not delved into all the nuances here, and that's just sort of a product of the time that we have. But again, I'm happy to answer any questions that any of you may have about anything that I just discussed or anything else.
Oh, I have far too many questions, but let me start. Nick, thank you for this high level, and I got to get a little more clarity about the Santa Clara case's procedural posture. So if you could be so kind.
Sure. So my understanding of the Santa Clara case is this: and I can start from the beginning. So the Santa Clara County adopted an ordinance where they proposed, I believe, that they would no longer enter into any lease agreements with a fixed base operator that permitted or sold leaded aviation gasoline on the field. And just for context, the FAA has not approved an unleaded aviation gasoline for use in aircraft. They're working on it. There's been a whole congressional push to try to get the FAA to phase in unleaded gasoline, but it hasn't quite happened yet. And so the FAA standard at this point is leaded aviation gasoline for most aircraft. And the FAA took the position that the county's action violated the grant assurances because it was effectively discriminating and precluding certain aircraft from utilizing those airports. It also took the position that it violated provisions of the Clean Air Act, under which the FAA has the ability to regulate aviation fuels as a source of pollutants, and I believe the Commerce Clause as well, because the county was effectively interfering in interstate commerce. Those were the positions that the FAA took. There were a number of meetings between the county and the FAA, and ultimately the county and the FAA signed a memorandum of understanding, and the FAA's investigation is currently in abeyance. And I believe that memorandum expires at the end of September. So they essentially gave each other some time to potentially figure out a solution until the end of September. That's the FAA investigation. Around the same time as the FAA initiated its own investigation, which of course is public, the Aircraft Owners and Pilots Association filed its own complaint with the FAA, alleging the county was violating all of the same things that the FAA itself had alleged. The FAA really does not have the ability to dismiss that complaint if, absent a legal showing that it doesn't meet whatever threshold standard. So that proceeding is ongoing, and the FAA is, I don't know whether they're going to just take that very, very slowly so that the new complaint doesn't outpace the FAA's own investigation. But the county is, in active litigation in front of the FAA with that industry group.
And so that's the forum is within the FAA and their regulatory
Correct.
process. And Santa Clara actually adopted regulations and then were said, whoops, fundamentally.
Well, so as I understand it, the ordinance is currently adopted but not being enforced. That's my understanding of where it stands.
So
and in some senses it was a little bit of a moot point because the FBOs that they have, that they have on the field currently were not selling leaded aviation gasoline. So it was it didn't have much of an effect practically. So it's less of an issue.
okay, thank you. That's really helpful. And I don't know how long a leash I've got from the chair. But I'm wondering about your knowledge of any changes at the FAA regarding the climate emergency and regulations that would come into effect, say, to increase fuel standards of fuel efficiency and the like.
I am not aware of anything at this time. I know that those discussions are ongoing within the agency, just from sort of anecdotally speaking with FAA folks that we work with on a regular basis. I do think that this is an issue that they are sensitive to. And as I mentioned, there is an ongoing effort from, as a result of a congressional statute that required the FAA to accelerate its phase-in of unleaded aviation gas. I know that effort is absolutely ongoing. But in terms of fuel efficiency standards, I'm not aware of anything that is imminent coming down the pike.
And are you aware of any other airports that are looking at fuel efficiency standards and are broaching that with the FAA or adopting regulations prior to approaching the FAA? Either one of those?
I am not, no.
Okay, thanks. I think that the last is sort of a grouping of questions, and it relates to noise. And so I understand your point related to the difficulty of crafting a regulation that would meet the FAA's requirements. But I would like to understand it. This may not be the time and the place for that, but I would like to understand what that type of standard, what type of showing we would have. And I would just say, just so that you know, I listened to what seemed to be about 13 of those fighter bombers overhead this morning as I was farming down in my flooded Intervale gardening area. It went on for a really long time. I am very, very supportive of the folks here who really believe that this city is not the place to be hosting and allowing the training of those jets. Among other things, noise. So I am very interested in understanding what the showing we would have to take, and the evidence and the standards, the decibel levels, the actual nature of the decibels, because there are a couple of different ways that you can read them, and the like, and what a regulation that might have a decent shot at passing the FAA's muster is. So that's a long way of saying is that I'm sort of asking maybe for more than what we can do now, but I just got to say, and I'll end by just saying the people here, in my estimation, absolutely deserve it, and they deserve no less, and we should be doing everything we possibly can to eliminate that problem. So.
Sure. Well, I think you're right in that it is a question that has an answer longer than what we have time for here. Those generally require a full noise study under what's called Part 150. And that is a complicated engineering and, sound consultant, noise consultant process that is beyond my pay grade, frankly. But there are standards, and I'm happy to work with Nick and his team to put something together that gives you a more complete answer on that. But it's an empirical standard, if I'm recalling correctly, that sets particular limits there with respect to those restrictions.
Great. Thank you very much. I appreciate that.
If I can add just a couple of contexts. One is specific to the 14 CFR Part 150, the noise compatibility program. We are and have been part of that program for decades. So we have a noise exposure map that came out in 2019. We are updating that map throughout this next 12 months, and it will be published next year. In the meantime, public meetings, public hearings, public communication regarding what that Part 150 process entails, not just on a noise exposure map update, but also the noise compatibility program, NEM versus NCP. The NEM is the map, the outline of eligible properties. The NCP is what eligible mitigation funding is associated within the contour lines defined by Part 150 and the federal standards. Right now, we have a host of available options of to homeowners, renters, and any residential property owners in some places of worship and things like that that are eligible within that contour line. Again, those are with public meetings, which the next meeting will be on September 14th at the Chamberlain Elementary School. We're currently advertising or starting the advertising process on that. It'll be a dual meeting, one associated with the investment that the airport's taking to maintain and to preserve the space across the street, so that it's a public use recreational path and park, essentially a park program connecting throughout that the Chamberlain neighborhood. We're presenting those ideas to the neighborhood to see and hear feedback associated with that program. I felt it was very appropriate, considering that we're talking about the areas that were purchased with acquisition funding through the Part 150 process, that we also update the neighborhood on the status of those programs as well. So that meeting will talk about both of those topics. And then the second point you made earlier on was about fuel, and Nick mentioned specific about no leaded fuel. And associated with FAA's program on implementing that or moving that more quickly. I also want to talk about the sustainable aviation fuel. We gave a presentation a couple of months ago. The FAA standards on that are still moving forward, but they have goals by 2030 to institute, and I don't recall the percentage of it, but institute those programs. Since that meeting, I've been working with Heritage Aviation to get sustainable aviation fuel delivered to the the Patrick Leahy Burlington International Airport immediately, as quickly as possible, even though the commodity is very difficult to actually deliver, especially to the Northeast. But we are on the list to Heritage Aviation specifically on the list to receive that. So both on the no leaded fuel, which is more for piston powered propeller aircraft, versus sustainable aviation fuel for jet aircraft, are both being discussed with our FBO operator.
If I could just say, so I appreciate the efforts of the airport to protect people from the noise. I think that that continues to put a burden on us and does not rightfully say to the Air Force that you need to do something as well. And so I actually see the question that I raised with Nick as, okay, you know, we're doing what we can to insulate all these buildings and protect these little kids when they're going to school from getting the shit scared out of them. Sorry, public. But that still puts it on all of us. And the fact of the matter is that it's just not right in my mind that the number of flights today out of that airport, one after the other, from 9:40 to 10:30 was just outrageous. There was an hour where that's the way it seemed when I looked at my clock and stuff. I mean, I was stopped from many things. You know, in communications, all, you know, for a long, you know, that's not an insignificant amount of time. And this is down in the Tommy Thompson's community garden by the Intervale Community Farm. So I want to know if we can meet the standards, because I understand about preemption, so I understand about their jurisdiction. But to be able to meet a standard that would say you can't fly that many times. I don't care how much insulation you put in the building. I don't care about any of this other stuff. You can't fly that many flights there. It's just not right. Take the damn plane to the desert if you want to go and train somewhere, not in the city. So that's what I'm looking for in terms of a Part 150 analysis. I totally appreciate what you're doing, but I think it's insufficient and it puts the burden on us. And I think that the Air Force needs to bear a burden. And I'm absolutely sort of curious, and this is as much for you in terms of looking out to ways that we can talk with other airlines, other airports, not just about sustainable fuel, but about efficiency standards, and see if we can make some progress at the FAA and with the federal delegation, because the planet's burning. I'm just speaking to the choir here, right? I know it, right? We got to do something more than what we are doing now, and that is, that looks like a path which is less litigious and more in line with trying to get the forces that are going to be necessary to make the change that we absolutely need. So in terms of the fuel efficiency, trying to make those changes in the airline industry, I'd really like us to be looking at that and being expansive within the confines that I think are accurately reflected in the presentation by today. So nothing surprising from what I'm saying.
Thanks, Jamie. I had a question going back to the slide where you talked about the FAA and how they have ultimate say on what is or isn't allowed. And I was just wondering, Nick, in your sort of review of this material, in looking at any of the existing sort of case law around it, are there any cases you can point to where the FAA has ruled in favor or along, favorably with a complainant with regard to noise?
When you say with regard to noise, are you referring to a restriction that the airport adopted to reduce noise?
Yeah, generally speaking, yeah. I mean, so if an airport wanted to reduce noise and created a regulation or restriction, and was the one that was either challenged or reviewed by the FAA and then ultimately upheld.
Yes, yeah. So there's quite a bit of case law out there about airport sponsors who have adopted, I hesitate to call them explicitly noise restrictions, because many of them are a ban on aircraft, for example, over a certain size or over a certain weight, or some other characteristic that does not specifically point to noise, with the intention of sort of getting around the airport noise restriction. And the FAA said, no, we see this for what it is. You are trying to reduce noise and you haven't followed the procedures, and this is an invalid restriction. There are also many examples out there of airports who have adopted an explicit noise restriction, and the FAA, or in some cases a federal court, has said, no, this is either not a reasonable restriction and it infringes on the grant assurances or the FAA's exclusive jurisdiction. Or in some instances, the courts have said, yes, this is a reasonable exercise of the proprietor's right to regulate noise. But that latter category is much smaller than those that have been invalidated. It's also somewhat difficult to separate out the earlier cases from the more recent cases because of the adoption of the Airport Noise and Capacity Act, which threw a pretty substantial procedural hurdle into that type of restriction. And the most recent case that comes to mind immediately is out of East Hampton, New York, where that airport tried to adopt a number of access restrictions that were based on noise, and the vast majority of those were invalidated by the federal courts.
Okay, thank you. I had other questions around fuel efficiency, but they've been asked already, so I won't ask them again. Well, I don't, do you have an additional?
I mean, I just would love to see the cases that, where noise restrictions were upheld. And I guess I'm understanding that they're all pre-1990, but.
They're not all pre-1990, but it does, I always hesitate to make sweeping statements in the field of airport noise law because it is very complicated. But the introduction of ANCA in 1990 sort of changed the calculus around things. So, you know, to the extent that there are pre-1990 cases out there, they may not have the same type of precedential effect as those after 1990.
It would be great if we can get those cases and we can get some clarity about the procedural requirements that need to be met. I mean,
sure, I'm happy to work with Nick on that and get something if that's the route we want to go.
thank you.
And thank you, Nick. And Nick, Dave. One thing I was going to do is allow James Lees, who originally had brought public comment to us that prompted us to ask for this review. He didn't make public comment, but wanted to make a statement, so I'm going to allow that now.
Okay, thank you. So, the airport presentation you just heard, actually in support of doing the following, and it's just 10 words. The city adopted a noise ordinance that's identical to the FAA aircraft noise standard for application to all airport users. The FAA only regulates civilian aircraft. So its noise standard applies to the civilians, but not to the military jets. We have two standards at our airport. We have the FAA standard for all our civilians, and we have no noise standard for our military. But the airport proprietor can establish the FAA standard as the standard for all aircraft, because the FAA regulations require the airport, if it's going to establish a standard, that it apply to all aircraft. Somehow, there's this loophole for military because nobody is regulating them, not the FAA, not the proprietor, the airport proprietor. All we have to do is say there are different stages for aircraft. Since the early 1970s, the FAA has been regulating the aircraft themselves. They have to meet a noise standard to get certified. Stage 1, stage 2, they're working on stage 5, which is the quietest noise standard. But stage 3 was adopted in 1990 as the standard that all aircraft must meet, no matter whether they're new or old. And the F-35 will not and cannot meet that standard. All the airport has to do for noise is establish the FAA's own standard. Who can complain to the FAA that they shouldn't be allowed? First of all, it wouldn't hurt any civilian aircraft whatsoever. They're already meeting it. The only one who could complain is the military. They would be the only ones who would meet it. So that is a solution. It doesn't require Part 150. It doesn't require all kinds of studies. It isn't preempted by it isn't preempted, it isn't ANCA, it isn't any of those things. We just need to establish the same standard. Now that's just the noise. But I think we've already learned from Nick that it's even more possible based on emissions, based on greenhouse gas. I think that's what I was hearing. So I think what we would want to do, now there's a third one also, and that's the military's own discipline. So there are 3 ordinances that the city could enact. One would establish the FAA's noise standard for all aircraft using the airport. The other would establish some reasonable miles per gallon, passenger miles per gallon standard. We learned from Nick, I think, that the big aircraft, the commercials, gets 120 passenger miles per gallon, whereas some of the F-35 only gets half a passenger per gallon. So some reasonable standard could be enacted. And then the third one is the military has its own regulations that prohibit intermingling of military operations with civilian populated areas. So I think that that's the basis on which, those are three separate bases on which the city could go forward and protect the civilian population and protect the planet. Thank you.
Thank you, James.
It might be helpful to get a reply so that we're all talking the same language, and if there's disagreement, then we understand, because Jimmy made certain, statements as if they were fact. And if there's a debate or a dispute, then we should lay that out. And if there isn't, then where there's a caveat or a nuance, then we should know that. So, I think.
Certainly.
Yeah, Nick, is there anything that you can respond to from Mr. Lee's comments, or something that we would like to respond in writing to after this? But I'll leave it to Attorney Clavers.
Sure. I'll work backwards on those three items. The first, as to the military's regulations, I really can't speak to that. I haven't reviewed those and don't really know what they say. So I'll defer on that to someone who may have more expertise on that. As to the greenhouse gas emission and passenger miles per gallon analysis, I think that would fall under the same type of impermissible restriction, because it would have the effect of excluding certain aircraft from the airport, and that's what that is what the FAA looks at. If the airport were to set a restriction saying that aircraft must be a certain color to use the airport, if there's even one aircraft that is that color that therefore cannot use the airport, the FAA sees that as an impermissible restriction. As I said, the only permissible criteria that the FAA allows for restriction of particular aircraft, setting noise aside for a moment, is safety-based restrictions. And the safety in that context is aviation safety. And airspace conflicts and things of that nature. It's not related to safety of environmental safety. Notwithstanding anyone's views on whether that is or is not an important safety consideration, it's just not part of the FAA's calculus in looking at whether those restrictions are permissible under the grant assurances. Then, with respect to setting a noise standard that matches the FAA's standard for civilian aircraft, I think that would run into potential issues, because it is explicitly done for the purpose of excluding the military aircraft from the airport. And I'll admit that this is not a situation that I've encountered before, so take this with the appropriate caveats and grains of salt. But setting a standard that in effect precludes one aircraft from the airport for much the same reason that the greenhouse gas emission or fuel efficiency threshold would exclude aircraft would have that same effect. I think you potentially run into a compounding issue there with respect to the grant assurances that require airports to make the facilities available to government aircraft at the same time. That's a separate factor there. The third thing that I would postulate, but admittedly say that I don't know enough to draw a conclusion about, is whether that type of restriction would be preempted not by the FAA, but by some sort of Department of Defense or other federal statute, either requiring cooperation or something of that nature. I don't know the answer to that, but the long arm of the federal government tends to take a pretty robust approach in defending, with respect to military operations. I know also that the city has a lease with the Vermont Air National Guard, and I don't know what that lease says with respect to those operations. So that's another consideration there as well.
Can I just respond very briefly?
Very briefly, we're over time.
Yep, there it is. On the government aircraft, the grant assurances, don't just say that it has to be available for all government aircraft. It says for use by government aircraft in common with all other aircraft at all times. So if there was a established ordinance for all aircraft in common with that, the government would have to select aircraft that meets that requirement to be in common with all other aircraft. I guess that's more than one thing, but I think I could answer all of you. I think it's kind of.
Thank you. You're welcome to submit responses in writing, and we would do that as we spend our time.
That would.
Do you have any other additional questions? Would you like to make a motion of anything?
Sure, I move that we accept all this material and place on file of our own committee, and also forward this to the city council for its consideration, leaving the question of whether there should be a deliberative session on it or not to the council president.
And I'll second that. All those in favor?
Yeah.
Aye. And that concludes this this important discussion tonight. I thank you, Nick, for joining us remotely, and Nick and Dave for joining us here in person. Appreciate it.
Thank you very much. Thank you, Nick.
All right, thank you all.
Next up, we have the GMT Fare Policy discussion. We have Clayton Park.
Hey, thanks for having me back. And so I'm going to walk you through our fare plan. And one of the things that I just wanted to check in is that the last time I was here, I talked to you a little bit about the history of why we needed to return the fares. And so I wasn't planning on talking about that, but if you want me to go into that, I can. And okay. And so what I wanted to start with is the routes that are going to be affected, and then what our fare plans are for there as far as the reintroduction of fares. And then I think probably most importantly is the discussion of how we're going to be able to cap costs, because I think that's sort of critical to understanding how the return will work. So GMT will be returning fares to the urban bus routes that go through Burlington and connect us to the different municipalities routes. Those are like the 1s, the 2s, the 6s, the 5s that you see on the streets. It will return to fare service for our commuter lines that connects us from, say, Milton and Heinsberg. And then our Link Express routes that connect us from Montpelier to Burlington, and then St. Albans to Burlington. And so thinking back prior to our going to a zero fare practice, the city routes were $1.50 with a $40 a month pass. The commuter routes were $2 with a $75 a month pass. And the Link Express routes were $4 with a $150 a month pass. And as you can probably imagine, there were a whole lot of folks that were buying that more expensive monthly pass. So what we are proposing is to simplify the route structure and the fare structure so that it would be a common fare of $2 across all of those that are returning fares. And so for our urban routes, that's a 33% increase. For commuter routes, that's staying the same. And then for link routes, it's actually a 50% reduction. The thing that will be critical is that we'll have price caps, because unlike the old system where when somebody would get in or get on the bus, they'd give their $1.50 or they would swipe a card with a magnetic strip. That card doesn't know anything about that rider, doesn't know that it's, Chapin Spencer and that Chapin has been, on the bus 10 times this week already. The new system will have that technology. And so what that allows us to do is that instead of having, going to people and saying, hey, you can get the best deal if you buy a monthly pass, we're flipping that around and say, once you get to the cost of our monthly pass, the rest of your rides are free. And so that means that people don't have to pony up the money for a pass. And they don't have to get into the situation where, gee, I hope that I use this enough to make it worthwhile. And so that's why I can make a statement where it seems paradoxical. I want to raise rates on urban routes by 33%, but no rider is going to have to pay more than they previously would have had to. And so that's because we're going to cap the amount each month to $40. And that will be across all of those. And so that will make regional transportation, obviously it's not more accessible than free, but free has been, but it will make sure that it stays accessible. One of the reasons why we want to do that is that we've noticed that the people who are using our service on the Lincoln commuter is different than it was pre-pandemic. It tends to be more people who are accessing services and medical appointments, because our belief is that many of our professional folks that would be coming, say, from Montreal to Burlington or vice versa, are now working remotely much of the time. And so we wanted to make sure, obviously, going from zero fare to $8 round trip for somebody who, say, come into the University of Vermont Medical Center, that's if they have to make that trip pretty regularly, that's going to be too much. So it really has been a balancing act of sort of compressing in a way, because what we're going to do is that for our casual users, they will be spending more because they won't use it enough to have the price cap come into effect. But for our folks who are daily riders, the price caps will kick in that will protect them. I also want to make sure that folks know that we have a discount system where anyone who is below the age of 18, anyone who is over the age of 60, or anyone who self-identifies as disabled gets a half price fare. And so there's no bureaucratic process. All they have to do is let us know that they consider themselves to be disabled, and then we will go into their account and they will be charged the half price. And that half price is both for, so instead of it being $2, it'll be $1, but also the cap will be $20 instead of $40. And so with this, the thinking being that our vulnerable riders will have their transportation throughout the region capped at $20 a month, which again, we realize is not as good as fair or free, but it's pretty good. And I think that especially for our folks who are using the commuter and link service, because previously they would have to pay their $4. And if they used another one of our buses to then get around town, they would then have to pay a fare on top of that. And I forgot to mention, in addition to the monthly rate of $40 and $20 for the discount, we're going to have a daily rate of $4 and $2. So essentially, if you pay for two rides, then the rest of your day is not.
You need that, you need a special card. You need that card.
They do need the card, and so one of the things that we wanted to make sure is that our cash-based riders would be able to have access to these protections. And so one of the things that we are finding is that even for folks who are cash-based, many of them have a smartphone, and so they're going to be able to do all that independently of us by just downloading the GMT branded app that comes with the fare system. And they'll be able to use that as their pass. It'll be a contactless where they just wave the pass over the fare box. And it works.
So right now you've got an app that shows where the buses are.
Yes,
That's going to be replaced.
we will keep both of them to start, and we're going to see how the bus tracking system and the GenFare app itself works, because that also offers tracking. So come January, our riders will be able to use the transit app and the GenFare app for their, and to see where the buses are at. If we find that we like the GenFare app enough to get rid of transit, then we may just unify them. We are not going to start at least, there is the potential that we would also then keep both and have people be able to pay in both apps. That makes us nervous though, because then we have two companies with all of our rider data. So we're probably hesitant to do that, but that could be a possibility in the future, because we recognize with many things, well, I prefer the transit app, or I prefer the GenFare app. Well, we want you to use whatever you can. But what the transit app will have is a connector, so that if somebody's in transit and they want to pay, they'll just go to pay, and instead of it them paying with that transit, it will then open the other app if it's already installed, so that they'll be able to access it instantly. Let's see, I was thinking more about the our cash-based folks, because we've spent a lot of time making sure that we're not overly burdening them. They will still be able to pay cash on all the buses, but they won't have price protection if they pay cash in that way. So for our folks who want to stay cash, don't use the buses that often, just paying cash on the bus is the way to go, and it will be just like it was before. Maybe a little easier because we don't have to worry about getting changed, so be one or two. When it comes to being cash-based and using the price protections, for the first 18 to 24 months, they'll need to come to one of our transit centers or GMT HQ, which is down on 101 in City Park Road. And essentially they'll just hand over their 10, 20 or whatever cash that they have. We'll then add it to their account. So that does mean that there is an inconvenience factor where only the transit centers or the HQ is where we're going to be able to have people add cash value to their cards. One of the nice things about the GenFare system is that it comes with connectivity to what's called the MCOM network. And that is a retail network that includes Walgreens, CVS, Walmart's. And so once that becomes active, then our cash-based riders can go to any of those places and give them their smart pass and give them cash, and that will be added onto the card. And so that will just make it much more convenient, obviously, because one of the things that worries me, I don't suspect we have a ton of cash-based only riders who are, making the connection from Essex to Williston. But if they are, right now, they would have to make a trip into town, to get their pass. So we recognize that. Eventually that will be resolved, but to start. I think that as you heard last time, we loved operating fare free. We think that this, if we do need to return to fares, is going to be a significant improvement over the past. I really like that we're not going to ask people to pony up money up front for passes. And the other thing that I really like about the system is that it'll make it much easier for some of our partners that want to either support employees or support clients of theirs or students to be able to fund transit, because what will end up happening with this system, and I'm gonna, pick on Howard Center for a second. So we'll be going to Howard Center and saying, hey, if you would like to support riders, you let us know which riders are affiliated with your organization, and we'll have some sort of secure way to do that. So there's been an authorization. And then Howard Center would be able to go online, have access just to those particular rider accounts to be able to add funds to it. So that way, if we had a particular, if Howard Center said, hey, for this client, we want to pay for all of their transit, they would be able to do that. If this client just needed transit on a couple days, they would be able to add, $4 for the day rate. And we think that is going to expand upon our previous work of having other people essentially paying for the service. Because one of the problems that we would have is that employers would balk at the they're going to be issuing passes to particular people that will then have an ID. That person no longer works for us, but yet they're still showing their pass, and then we send the bill saying that we counted X number of folks. They're like, well, gee, that's way more than who we have working here, and so we think that will be helpful. We suspect, and this is getting into the weeds probably more than you're interested in, but our big providers of free rides through CATMA, which is the Chittenden Area Transit Association, and they represent Champlain College, UVM Medical Center for free rides for those students and employees. At first, we thought that they would be psyched about being able to only pay for their rides. What we found in negotiating with them, that they actually find that it would be more helpful to have a negotiated rate, because then the problem with paying for how it's used is that then those costs can vary pretty widely from month to month, and they seem to be much more interested in having hey, this 400,000 you provide a year, that's good enough. So I think that there still will be some of the large partners that won't use the system, but some of the smaller ones. And that should happen with no cost. So if an employer says, hey, we want to pay for our employees to be able to have service, we can set that up for that without charge. So that's kind of, in a nutshell, I do think it's paradoxical that we're, that we're talking about a significant raise and single rate while, kind of constraining. I can tell you that one of our concerns is that the legislature, I think, became suspicious that we wanted to give away our service, and so they gave us a target that we have to generate 10% of our revenue, urban revenue via fares, so that we don't discount too heavily. And we think that we're going to be able to achieve that 10% with this, but once we have the real data, we may need to adjust again, because our ridership data right now is not granular enough so that I would be able to say, what percentage of our riders would reach that $40 cap if their rides have to. And so that's going into it, sort of the concerns that we have on that.
So starting with the last point, which is about demographics. I mean, this is very much about demographics. It's about where people are going. It's about their socioeconomic status, so to speak. It's about their age. It's about their disabilities. So, are you collecting that granular information?
So moving forward under the new system, we're going to have great data on where people get on the bus. We're not going to have the best data on where they get off the bus. But the thing that would be nice is that, unlike in the past, we can pick a specific stop and we can say what percentage of riders who get off, or get on at this stop are being paid for by Howard Center, are receiving a discount, or, you know, whatever, so that, like, right now, we can't tell if that 10 people who are getting on the bus are sort of what we call choice riders who are paying the full price, or if those are 10 people who are getting on the bus, that's their only, you know, option, and they have other vulnerabilities. We do hope, although it may be too aggressive for me to say this, that by the end of 2024, we have at least partial deployment of automatic counters for seeing when people get off. We won't have the granularity on when people get off, what pay model that they used, but at least that will then give us an idea of along the way, this is where people come on, this is where people come off, so that we can do sort of like real grown-up data analysis on our service.
You were mentioning CADMA, so we have now got citywide for larger developments, transportation demand management requirements, and they're ongoing. So have you looked or worked with the planning office, the people who are doing the permitting of new developments that have got these new requirements to encourage them to get their folks on the buses? If not, I can suggest you do.
I can tell you, I don't think that there's coordination between that and the GMT. And at least not that I'm aware of.
I would plead with you to do everything you can, and if you would like some assistance from a city councilor, I'd be happy to be the pain in the ass that I am.
Well, you know, it is interesting to me because, for example, I heard some of the new apartments complexes in Colchester, you know, were able to get reduced parking requirements because of access to public transit, and I'm like, we don't provide public transit anywhere near there. I wonder how they're doing that. And so,
it would be very helpful if it was a regularized process by which you got information, so that, you know, whoever you have to do outreach to, a developer, to an owner, to a business. That would be great.
I can tell you that I think that totally makes sense. I will certainly, Chapin, I hope that this is something that you could perhaps guide me a little bit on how we would go about implementing.
Sure.
And although at the same time, I know that I would be hesitant to create anything that would be perceived as another barrier for, oh, we got to get GMT sign off before I build my apartment. But
no, this is more like they've got to choose between a list of options, and it's part of their permit, so it's public information. You should be able to access that. So Chapin should be able to get you a hold of that. It's kind of pathetic that we don't act on that. The outreach for to the current riders about the changes, and because there's a lot of logistical changes that people are. What are you doing for?
Thank you for asking about that, because I was supposed to mention it in my presenting. We will have additional temporary staff starting in November and going through the end of January that will be doing outreach events throughout the region, where we'll be advertising, you know, hey, come down, create your bus pass so that on January 2nd, you know, you'll have it and be ready to go. We're bringing on temporary staff to staff those, and so I'm guessing, I hope the weather is nice, because there will be folks, you know, working on the platform, downtown transit center, people that are rolled in advance, and that's when we'll be able to talk to them about how it's going to work and get them signed up. We are also working to get videos on how to use the system and have it translated in different languages, so that we can reach people who are not native English speakers. And if Jamie, our marketing person, is here, she could go down the list of other things, but those are sort of the big ones. I think that, you know, one of the things that amazes me about signs is how we've become so used to not seeing them. And so there will be signs inside all of the buses. There will be signs at the downtown transit center. And I'm sure that unless we have people like, you know, almost cold calling, hey, get your smart pass, you know, people will be surprised out of the January. What do you mean we're going back to fares? You know, so we know I have to do that on that.
My suggestion is actually you put people on the buses, maybe in November or or for the month of December to let people know.
We got so lucky because we got an AmeriCorps Vista employee whose job is riding the buses and how it looks out. So she is will be our primary person.
Excellent. The last question is College Street. The College Street shuttle is still free. Yes, does that happen? Do we have any? We have put monies in the past into free routes.
I think that we're still figuring out which route we want.
Correct.
Yeah.
So the council historically has approved a budget that's allowed the College Street shuttle to be free, or what's now the merged College Street shuttle and South Burlington Circulator.
Yeah.
So the Burlington portion of that route is free. You also passed a resolution looking to make the Old North End loop free as part of the North Winooski Avenue effort. The money for both of those, we've asked GMT to give us what that's going to cost as of January. And we're going to measure that against our assessment and see if we can, our budgeted money for the assessment, see if we can afford that. And it's possible that we're going to have to pick one or the other or modify the fares on those. But we're going to have that conversation before January.
Yeah. And Chapin, the way you so wonderfully worded that makes me think that we haven't given you that information yet.
That's the way, that's okay.
Okay, yeah.
That's why you're here.
Exactly.
Yeah.
So that we can make sure that all these things are taken care of.
I can tell you the thing that worries me is when we return to fares, having that awkward situation where, all right, everybody, we're past the free point. Everybody on the bus has to get up and pay a fare now, and that's, you know, I'm not sure how we're going to resolve that. And we're going to have a similar situation. I should have mentioned earlier with one of our commuter routes, because Tri-Valley Transit does some of the runs during the day. We do some of the runs during the day, and it's going to be this awkward situation where unless we waive that, you know, people will have to know which are the free rides, which are not the free rides. Yeah. Luckily, that doesn't generate enough ridership that if we were to waive that, that it would be a significant loss.
I had quite some basic questions. I couldn't glean from the memo whether or not if someone transferring would have to pay, would the $1-2 fare cover the transfer as well?
The transfers will no longer be covered, and that's why we went with the daily cap of 2 rides being the cap for the day.
So that one ride may cost $4?
Yes, and so the one-way traffic is going to be a place where people are going to be. We believe that most of our riders are round-trip riders. But for folks who say use the bus to get into work and then have other means to get home,
Right.
They potentially would have that.
So I'm thinking about like school riders. So that was my next question is there's a relationship between GMT and the Burlington school district. And I'm wondering, you know, some of those riders, they may ride the bus in the morning, pick them after school, have,
Yes.
you know, other circumstances. So then I'll just sort of parlay that question into how will the new system work for Burlington School District, including water department?
They'll still get on, show their ID and have a free ride, and they won't need to have any type of pass. One of the things that I'm not crazy about is that like I would like for that pass to, or for that to be able to do that at any time. the school has kind of wanted us to limit it, for liability purposes to, just adjacent to school hours. So I know we're still working on that with them.
Thanks. So basically no changes for that.
Yeah.
The other thing I was thinking about, and it's really, it's come up with like Park Mobile. There's a demographic of users who are like averse to Park Mobile because they don't use their smartphones well. And I know
It
that
doesn't work great.
Yeah.
I don't think.
But essentially, and I'm not gonna like
Sorry.
generalize, but I know anecdotally,
All right, let me know when it doesn't work.
a number of older users that wanna park, and I know that Jeff Paget at Parking is coming up with a potential system to address that. But I'm wondering about like the demographic of the bus ridership, whether or not there's older users who may not be as tech savvy and may have an aversion, and they would be, unintentionally sort of penalized for that tech aversion. And if there's anything that GMT is contemplating to address that.
What I would recommend that they do is that they just get the smart pass, and because then they can have all the price protections. And it's the smart pass, you can add a credit card or debit card to it, so you set it up once, you never have to about it again until you lose your credit card.
Okay.
We were talking before about the smart passes requiring payers with cash to go to the transit center, but if they are paying their smart pass with a debit or credit card, they don't ever have to go in. And so that's what I would expect that we'll be asking people when we have the events is, what do you feel more comfortable with? Because the other thing that's nice about the card is my understanding is that since it's a proximity sensor, instead of having to run a swipe through, I could potentially just have it in my wallet without, And so asking people, is that the experience they want, or do they want to wave their phone? I think that many people will want the simplicity of the plastic card that just, they don't have to think about it once it's set up.
Will those folks be able to like call GMT and order a smart card potentially and have it like sent to their house? They can set up the bank connection and all of that.
Again, for the non-cash payers, we'll be able to at the headquarters take a call. Somebody says, "Hey, I lost my smart pass." We'll turn off the old one and we'll send them a new one. And that's also the benefit of the system where, if you paid $40 for your monthly pass, you lost it, but you're out of luck.
Okay, and my last question is really around the potential effect of legislative action on this plan. I mean, I'm thinking about the legislative session. It doesn't begin until January, that you're anticipating the start is January.
Yeah.
So this will be in effect regardless of, or something like this will be in effect regardless of any action the legislature would take.
Yes, they require that we provide them our fare plan by December 1st because they wanted to see what that would look like. And yes, their expectation is that by the time they come back in session, they're reflecting fares. I can tell you that I'm worried that it may be more like February 1st because one of the things I'm finding in my new gig is that everything takes longer than I expect in transportation. And I thought that I had a handle on understanding government systems from the human services side, and transit is slower. So, it may be more like February.
Well, I don't have anything further.
February for this to go into effect.
Yeah. What we don't want to do is start to have conflict. We know that we're going to have one shot to have this work correctly for folks to, be like, okay, I can do this.
Do you need to get V-Trans approval of that?
If we wanted them to pay for the lost fare revenue, we would have to get their approval, but we're going to take it out of reserves if we can't do it. So there's a huge incentive for us to do it, about $166,000 a month.
And is there still work on the sustainable funding front?
There is. I can tell you that, so Vermont Public Transportation Association was asked to provide a study with recommendations on how to obtain non-federal match. And I think that their leadership has taken a position that the dwindling COVID funds, they're being extremely conservative about what they're asking for. And so I think that they are planning on making a recommendation that would only generate between 1 and 5 million statewide to be distributed. And so I don't suspect that that is going to help us significantly in terms of reintroducing fares or not. And so I think that their hope is that this would be the classic, snout under the tent. And then once a mechanism is in place that potentially, expand. But I think that the going into the second year of a session, going into the second year of a session with a governor who's openly hostile about new revenue sources, I have a feeling that a better long-term solution may come, at a different session. My prediction, just to show you my cynicism, is that just as we have perfected our fare system, that we'll go back to zero fare, and this will just be a character building exercise.
Thank you for coming and updating us today.
Thank you. Always happy to talk to y'all. And Chapin, good to see you twice in the same day.
It is, and I think just to finish up, the board's going to be asked to approve the fare plan. Generally, it has been positively received by the board and by the public. I am generally supportive. There's a lot here that I like, the capping, the additional kind of ways to pay, the order over the phone, all these things that we currently don't offer or we didn't offer prior. So I think you all raised some good pieces. I've taken notes. I will see what needs to be worked on in advance of work with Clayton, but I expect the board to approve this in the next month or two.
Hope so. Thank you so much. I look forward to being back. Tell me how it went.
And we do have a new commissioner, Andrea Suozo, and a new alternate, Will Anderson, who's joined Tom Darenthal. So I've been emailing them collectively. The new members are getting trained in an orientation next week, and I'm trying to get them up to speed the best I can. So feel free to loop others in. I shouldn't be the only conduit to GMT.
What? I thought that was your.
You want more people than just work, Chapin.
Yes.
Before we move to our next item, I want to go back to our last item and ask Maddie, we actually voted on that.
See if
motion. We did? Because I know I seconded it and I had this
I wrote all in favor.
Sounds good to me.
Okay, but we are in favor. Yeah, we'll be on record as having voted unanimously.
I thought I heard a vote.
Okay. Well, we have the recording. So. Our next item is the North Winooski Avenue update. Turn over to Chapin.
There's a memo in your packet.
Yep.
We're proposing a plan to continue to support the community health center in their efforts to look at off-street parking development. There's a bunch of information in the memo. There's a proposed motion. Given the time, I'll just see if you have any questions.
I would like to read an email that I got as a follow-up to a telephone call I got from the Dolan Auto place on Winooski Avenue, Mr. Bergman, as a follow-up to our conversation minutes ago. Dolan's Auto hours are from 8 a.m. to 5 p.m. Monday through Friday, and we've been here for 4 years. For the telephone. We have deliveries almost every day and sometimes many times during the day. Snap-on Tools got a $75 ticket on August 8th from the parking enforcement for delivering a tool because he was parked in the street with four-way flashes on for a couple of minutes. This person never got out of the car, meaning the parking enforcement person took a picture of the truck and sent the ticket in the mail. I will have Snap-on appeal for a refund and have him send you a copy as well, which I did get. We need a solution to this. Our business is suffering from the lack of parking for customers and now for deliveries. We need your help. Signed, this is the owners, Nancy Howard and Sean Dolan. I think that we need to have a loading zone. Or some clear, I thought that we weren't going to be enforcing until September. And so the idea that a business getting a delivery, getting, having their delivered, get a $75 ticket, 8th of August, in the run-up to this, this isn't good. And even if it were all legit, I think that what she told me, it is not in here, but that the delivery zone is on the other side of the street, is too far away for, and basically you're talking about deliveries of heavy stuff. And so the need to be able to make a delivery on the street, just like FedEx runs in, even when they're not parked on the right side of the street, they're doing it all the time. So I think that we need to create a loading zone so that they can run their business. And as a biker, sometimes I've got to move out into the street or something changes. And I think that particularly given the low bicycle traffic on that street, that it will not be a bad thing particularly as we make this transition. So that would be my request. Yes. That we get this company an unloading business delivery zone so that they can get their stuff and not get driven out of business. I'll forward you this and the ticket because I got that.
Great. Chair, do you want to focus on the issue that was on the agenda, or do you want me to respond to that? How do you?
You're welcome to respond. I think as a general update, we will get it to the issue.
Right.
Can't remember, but please respond.
Yeah. No problem. It's helpful to get feedback on how this is rolling out. I think if I understand the person, the truck was parked in the bike lane. We do not have anywhere in the city where we permit parking in a travel lane, whether it be a motor vehicle lane or a bicycle lane. There was a process to look at where the loading zone should be. I can look back and see where the Dolmans requested to have the loading zone on the other side of the street. If they can't pull into the driveway or use the loading zone, we can explore other solutions. We had promised warning tickets for people who did not comply with time-limited parking restrictions. That's the language that was put in the memo. That's what we have gone to the commission with. And this sounds like it was not a time-limited parking violation at a time-limited space. It was a parking in a bike lane. So that's why they got the $75 ticket. We did reduce the time-limited violations down to $20. This wasn't a time-limited violation. So I'm happy to follow up with whatever additional information there is, and I can look. If they did park in a bike lane, that is city ordinance. We could look at changing city ordinance, allowing parking in bike lanes, probably a slippery slope. But that's, I think, why the situation occurred the way it did. Happy to talk.
When I was talking with her, a FedEx truck pulled up to my neighbor on the wrong side of the street, right? There's no parking on the street. It's a travel lane. He got out, he delivered parking. I see it happening all over the place. It's a short operation. I just forward you this material. I would ask that you support a, in the interest of good community, service in this transition, that you see, they're gonna appeal, that you weigh in with the city attorney's office to waive the fine. I think that I would also ask that you reach out to the Dolans and figure out a solution to what I think is going to be a problem. They say that the other truck unloading or the unloading zone is too short period of time. It's only in the morning, and it's always full, is what she said. I haven't independently verified that, but I'm gonna ask that you do that.
Sure. We can absolutely reach out, and we can absolutely change the hours of a truck loading zone if requested by adjacent businesses.
I would just add to this that I, as a North Avenue user, I see this practice with delivery trucks and others parking in the bike lane to make, because there's nowhere for them really to pull off. So this is, even if it is against city ordinance, I think it is a common practice. Not that doesn't make it right, I'm just saying that this is what they're used to doing. And so we could be more explicit, or we could update the ordinance or do whatever we need to do. But clearly there's a discontinuity there that needs to be addressed. I would agree that during this transitional period, we should be a little bit more lenient on people getting used to the new configuration. And it was an oversight on my part to think that, I mean, I think you're right. I mean, it was for time limited parking, but I would maybe be even more generous than that in some of that.
Okay. I would love that. I think that the sensitivities that exist around this and there's continued opposition to it, and I do not think that it does the comprehensive transportation strategy any good to have the conflicts that are easily avoidable. So I would agree with you 100% in terms of.
What a great pivot to our topic here around trying to further the off-street parking efforts of community health center. So could you talk a little bit more about, I know it's in the memo here, but just for those who aren't reading the memo, might be watching. What happened and how this came about, and then we can go to the action.
Sure. City staff have been working with CHC as well as some city councilors, including Councilor Bergman, Councilor Paul, to try to find ways to help. Community health center has a lot of employees. They've been traditionally using on-street parking for their employees. And as we all know, on-street parking has been constrained with the installation of the bike lane. So at first, we ran a $15,000 grant program that you all helped us allocate funds to several groups, including CHC, the community health centers. And CHC has done some geotechnical work. They had originally thought that they had to provide access to this additional parking through their lot and not through any adjacent lot. But in further conversations with other property owners, there's receptiveness to having access through others' lots, as long as it's just for staff and wouldn't be coming and going of the public every day. So that has opened up opportunity to look at design solutions that are simpler and potentially cheaper than the $1 million proposal that they had designed from their consultant. So we, in good faith, would like to offer some planning design funds to go back and do some additional design work and geotech work to understand if these cheaper, simpler solutions could be viable. We have looked for funding for construction, both CHC as well as the city. We haven't gotten a lot of traction, haven't found good fits. It's likely, since this is a private lot for private use, i.e. their employees, it's going to be harder to find public grant funds. And as such, you know, this is one way we can help leverage some public funding for them, with the understanding that then this cheaper option would be theirs to construct, if it's viable.
Well, I support that.
We do as well.
I would move the proposed motion as stated in the memo.
I will second that. I guess I would like clarification before we vote on who will be authoring the council initiative fund request. Will it be staff?
I'm happy to do it either way. So if it's your preference to have staff take care of it,
We
we
can
can
draft and forward it to the committee members to.
Okay.
review and-
Yeah, I mean, because this is approved by the
Goes to the Board of
by the
Finance.
Board of Finance. It's small enough that it's there.
I believe so, and then it will end up. Yeah, I believe that's correct.
I think that's the only place that it needs to be this approval.
Yeah.
Yeah.
Okay.
I'm happy to move it.
Circulate to two members. Got it.
Okay,
Okay, so now
all
we do
those in favor, so I don't miss a second.
Aye.
All right, there's only two of you, and
Very much.
when you hit your seconds, it's sort of assumed, right?
Yeah,
Okay, so.
appreciate the time, and I will follow up with Dolan's and keep Gene updated.
So what I'm gonna do is send is say that I've had this conversation, I'm going to the people I asked for. I will include you in that and say that you were going to reach out to them. And I'm gonna include the driver who I've said you need to appeal, you know, and that's the process there's no other way to go about dealing with that. Yeah.
Our next item is the director's report.
I'm good. Thank you.
Councilor updates.
So I see these electric bikes all around the city, sometimes parked in the middle of a sidewalk. I would like an update. I see them parked all over the place. I've only seen a few people riding them, so I would really like to know what as a bird, so what a bike is doing. And then I had a list of other things that I just think that we need to get in front of us. Again, and it could well be actually that a conversation about TDM would be good in light of the conversation that we had on GMT, because dead litters.
Okay, I'm glad you brought up the bird bikes. I had similar questions about the fact that they are everywhere. Would lend one to believe that they are being used, but
Yeah, I'm happy to bring a report to the next meeting. I don't have the numbers in front of me, so I can't speak to it. I don't know, Maddie, if you have anything. I know Julia and Rob and I have been kind of point people, so.
And with regard to your the other ideas for scheduling, I think those are definitely in the hopper, and we're sort of working through those things.
Yeah,
as we come in, depending on.
I've written down the bike share piece. I'll add the TDM to our planning document, so we don't lose that request.
Great.
Maybe TDMs, if it's either maybe it's sustainable, maybe it's quite.
You know, I think we could think about how, you know, how we can organize it. There are a lot of pieces and parts and yeah, so that might.
I don't have anything additional. Next meeting, 9/26. Does that work for everybody?
I think so. I think once again, I've left my phone on my kitchen table.
Can we get this room on 9/26?
Yeah, I've already booked out for.
Okay, excellent.
Excellent.
Okay, good. And then with no further business, I will adjourn us at 6:56. 26 minutes later than I intended, but we gained 20 minutes on public forum and
Yeah.
squandered it all somehow.
This is good.
Good deliberative process.
Thanks, folks. I'm gonna run to